Can you sue your employer if you quit your job? The answer is yes, sometimes, but not always. For many employment claims, quitting your job will actually prevent you from being able to sue your employer. And for other employment claims that you can still sue on, the damages may be severely limited if you quit. That's not to say that you should stick with a job that makes you miserable. If you need to quit your job, then by all means quit your job. The purpose of this video is not to talk about whether or not you should quit your job, it's to talk about the legal implications if you choose to quit. So stick around to find out more. Can you still sue your employer if you quit your job? Well, the answer depends on the claim that you're bringing against your employer. In order for you to win your employment claim, you will need to show that your employer took an adverse action against you. And that adverse action is different for different claims. For claims of discrimination, where your employer treated you differently because of your protected characteristics, you have to show that your employer actually changed your employment status. Termination is the clearest way to show a change in employment status, but other things may also work, like demotion or failure to hire. For claims of retaliation, where you engaged in some protected activity like reporting discrimination, you have to show that your employer did something that would dissuade a worker from engaging in that protected activity. Again, termination is the clearest way to show that, but other things may also work, like showing that you got reassigned to a new job that was less favorable, or showing that you got demoted. And for claims of wrongful termination, where you engaged in some protected activity like reporting your employer's violations of law, you have to actually show that you were in fact terminated. So as the name suggests, wrongful termination does require a termination. It doesn't work if you quit. But even when you can bring a claim without being terminated, what you can recover for that claim will likely be severely limited if you quit. The money that you collect if you win your employment claim is called your damages. And damages in employment claims are composed of your lost wages and your emotional distress. And that first part, lost wages, are a crucial part of your damages. Lost wages are the wages you would have been paid had you remained in your position. They are easy to calculate and easy for a judge and jury to understand. If you have a lot of lost wages, it will also enhance your emotional distress damages too. And here's the important part. When you quit your job, you cannot collect lost wages. And without lost wages, your damages are greatly reduced. And if the damages are only based on emotional distress, it will be much more difficult to calculate and much more difficult for a judge or jury to understand. And without a number to anchor to, it will also probably be really tough to find an employment lawyer to represent you, because employment lawyers usually work on a contingency basis, so they only get paid from the damages they recover for you. Without lost wages, it's hard for an employment lawyer to measure your damages and weigh the risks of taking on your case. That's why most employment lawyers only take cases where the worker is actually terminated. So the key takeaway here is that workers who quit their job are generally not able to collect lost wages. But there is one big exception to that rule, and that is when your resignation qualifies as a constructive discharge. So let's talk about that now. If you quit your job, you generally cannot collect lost wages, which are a crucial part of any employment claim. But the big exception to that rule occurs when the employer intentionally made your working conditions so intolerable that you were forced to quit. In those situations, courts treat your resignation as if your employer terminated you because you had no choice but to quit. And it's called constructive discharge. But to establish that your employer intentionally made your working conditions intolerable is not easy to do. In Washington state, we have 4 elements that you have to prove in order to establish constructive discharge. First, you'll have to prove that the defendant deliberately made your working conditions intolerable for you. Second, that any reasonable person in your position would be forced to quit. And third, that you quit because of the intolerable conditions and not for some other reason. And finally, that you suffered damages as a result of your forced quitting. Now, I'll have to make another video about how to prove those elements, or else this video is going to go on forever. But suffice it to say that it's a difficult thing to prove. The final thing that workers should consider before quitting their job is how it will affect their ability to collect severance and unemployment. First, let's talk about severance. I get a lot of calls from workers who want me to negotiate a severance package for them when they quit their job. And generally, if a worker quits their job, the employer is not going to offer any severance. Employers usually only offer severance packages when they terminate the employee. Severance packages are ways for employers to pay you to waive your legal right to sue them. So generally, employers only offer severance packages if they think there is some risk that you might sue them. And as we've already talked about, quitting will severely reduce your ability to sue your employer. And if there's no risk that you're going to sue them, they won't pay you a severance package. Now let's also talk a little bit about unemployment. And before I do that, I need to tell you that I do not handle unemployment claims. So I am not an expert in this area and do not call my office about unemployment claims. I'm just going to briefly go over how quitting may affect your ability to collect unemployment benefits. Generally, unemployment benefits are only available to people who lost their job through no fault of their own. So if it is your fault, like you quit your job, you generally cannot receive unemployment benefits. But that comes with a huge caveat that there are a whole bunch of exceptions to that rule. If you can show some good cause reason for quitting your job, you may be able to still collect unemployment. Now, unemployment rules are going to be different from state to state, so check with your state's unemployment department. But just know that quitting your job may impact your ability to collect unemployment. Okay, so there you have it. Now you know how quitting your job affects your ability to sue your employer. While quitting may block claims like wrongful termination, it doesn't block all employment claims, as long as you can show that your employer took some other adverse action against you. However, quitting will impact the amount of damages you can collect. And it will also impact your ability to hire a lawyer, negotiate severance, and collect unemployment. If you enjoyed this video, give it a thumbs up and follow my channel. I make videos about the laws that protect workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.